For years, conditions at the Golden Grove Adult Correctional Facility have come into question, and that's why the Virgin Islands Bureau of Corrections and the Virgin Islands Department of Justice have been operating under a federal consent decree for the past 25 years. Recently, Corrections Bureau Director Julius Wilson challenged that directive and requested that the court vacate the 1986 decree put in place by the U.S. Department of Justice for concerns like security, fire safety, sanitation, and accessible health care for inmates. Wilson and his legal team are citing the U.S. Prison Litigation and Reform Act, which, according to the opinion written by District Court Judge Wilma Lewis last week, was enacted to require that remedies in prison condition lawsuits do not go beyond the measures necessary to remedy federal rights violations, but rather are limited to the minimum necessary to correct the violation of the federal right. In essence, it limits federal oversight of state-run prisons like Golden Grove. Arguments were presented back in December, and Judge Lewis in last Wednesday's opinion said that of the 7 court orders issued under the 86 decree, only the 2006 one assigning a special master to oversee reform implementations met the federal qualifications required under the PLRA. Judge Lewis further determined that those other 6 court orders constitutes prospective relief within the meaning of the PLRA. The opinion also talks about major differences in the 2006 and 2011 reports submitted by the special master that make it hard to track the progress at Golden Grove. Judge Lewis goes on to say that an evidentiary hearing will have to be held to see if there are any ongoing violations of a federal right at Golden Grove where prospective relief might be needed, and if so, to determine that relief. Reporting for News 2, I'm Erica Parsons.